I want to share with you the words of Justice Michael Kirby, our first openly gay High Court judge, from a speech he gave to mark the anniversary of the Wolfenden Report, which recommended the decriminalisation of homosexuality in the United Kingdom. It's one of the most powerful things I've ever read. He said, "If I close my eyes, I am back in 1958, my first year in law. I can still see Mr. Vernon Treat QC coming to the stage to give 100 first-year law students another lecture in that most important discipline, criminal law. I can hear him talking about the sections of the Crimes Act 1900 of New South Wales dealing with unnatural offences. I can still recall his rasping voice as he intoned the old provisions of Section 79, spitting out the exceptionally ugly words of denunciation in the parliamentary prose. Whoever commits the abominable crime of buggery or bestiality with mankind or with any animal shall be liable to penal servitude for 14 years. There, sitting on the strangely plush seats amid all my friends and colleagues, I felt the blood rushing to my face. I shuffled my papers. I looked down. Do any of them know? I asked myself. I hope they cannot guess. I could not bear the shame. I should be very, very quiet, and then maybe no one will ever know. No one will ever guess. I will get through life alone and sexless, but I would rather die than be seen on the front page of the Mirror. These were the means by which the law became an instrument not of liberty but of oppression, not of equality but of discrimination, not of human happiness but of cruelty and unkindness. G'day everyone, Anthony Marinac here. Today we're going to look at the experience of lesbian, gay, bisexual, transgender and intersex people under the Australian law. We're going to look at how for this part of our community the law meant oppression, discrimination, cruelty and unkindness. And we're going to look at how things have changed and what challenges remain. It's likely that homosexuality has always been part of human behaviour. Some ancient prehistoric art seems to depict intercourse between men. We know the ancient Greeks quite openly practiced homosexuality. We know the ancient Romans practiced homosexuality. We know that homosexuality must have been around for the early Israelites, or else the author of Deuteronomy wouldn't have bothered making a law to forbid it. We know that in some environments, such as the Royal Navy or in prisons, the enforced absence of women for years likely led to homosexual attachments. Churchill wasn't in jest and wasn't really insulting when he said that the traditions of the Royal Navy were rum, sodomy and the lash. Attitudes to homosexuality varied from culture to culture and from era to era. Those attitudes seem to have been linked to the society's need for reproduction. In societies which were teetering and which needed the production of generations, homosexuality appears to have been frowned upon for the obvious reason that homosexual couples do not produce children by birth. In societies which were affluent and which no longer had a pressing need to increase population, homosexuality served a useful purpose, almost as a form of contraception, allowing sexual activity without producing children. This suggests that there have always been men who are attracted to men, women who are attracted to women, and also people who have from time to time engaged in sexual activity with both men and women. It also suggests, convincingly in my view, that there is no inherent moral position in relation to homosexuality. Whether a society was permissive or restrictive in relation to homosexuality, these were social constructs and not a matter of some nature that required universal heterosexuality. In our society, Christian ethics were always dominant. Christian ethics in relation to homosexuality are very complicated. The Old Testament quite clearly makes homosexual sex between men an offence punishable by death. However, recently we've heard of widespread homosexual activity within the priesthood, often with young boys as the target of that activity. It would surely be naive to believe that these actions only commenced in the 20th century. Be that as it may, the Christian doctrinal position was that homosexuality was forbidden, and it became the law in England, as a result, the law in Australia. This law found its most clear expression in the criminal offence of buggery, or the sexual penetration of a man by another man. Surely this law stands high among the most unfair and outrageous laws our statute books have ever held. Thousands of men in Australia and the United Kingdom were tried and convicted of these offences. They were publicly branded as perverts. They were, as Justice Kirby alluded, shown on the front page of the most salacious newspapers. Some were chemically castrated. Perhaps the best known example is one of the finest minds of the 20th century, Dr. Alan Turing, a man whose work helped shorten the Second World War by 2 years, saving millions of lives. The man who essentially invented the modern computer. They were originally known as Turing machines. Turing was convicted for his homosexual activity, subject to chemical treatment, and it's still not clear whether his death by poisoning was suicide or accident, but there's every reason to think it was the former. The 1957 Wolfenden Report, which was mentioned in our introduction, led to the decriminalisation of homosexuality in the United Kingdom in 1967. Australian jurisdictions gradually followed suit, with the sad exception of Tasmania. In Tasmania, homosexual sex between men remained criminal until well into the 1990s, when Nicholas Toonen took the state government to the United Nations Human Rights Committee, which agreed that the law infringed his rights under the International Covenant on Civil and Political Rights. This gave the Commonwealth Government the excuse it needed to squash that Tasmanian law, which it did in 1994. In 2013, Alan Turing was formally pardoned for his conviction, and in 2017, a law customarily known as the Alan Turing Law was passed in the United Kingdom, retrospectively pardoning all of the men who had ever been convicted for homosexual sex. In 2016, the Premier of Victoria here in Australia formally apologised to all the gay men who had been convicted of buggery in Victoria, including those who had been executed when it was a capital crime. In 2017, the Premier of Queensland did the same. From a tradition of contempt and regarding gay people as perverted, we've now reached the point where the law no longer holds any fear for them. But for gay Australians as a community, how does one erase the knowledge that for most of our nation's history, their very sexuality has been a crime? From the early 1980s, HIV and AIDS became one of the most massive health issues in human history. Even today, there are millions of sufferers around the world and billions of dollars spent annually searching for a vaccine, a cure, and ways to treat those suffering from HIV and to extend their lives. Attitudes towards homosexuality has been stained in the decades since the 1980s by the association of the disease with men who have sex with men. Indeed, AIDS itself was briefly known in the early 1980s as GRID, which stood for Gay-Related Immune Deficiency. It was first seen as a widespread problem within the gay community in the USA, and the death from AIDS of some prominent gay entertainers such as Freddie Mercury from Queen, actor Rock Hudson, and Liberace gave the disease prominence. This early association between homosexuality and HIV further marginalised gay people within our society. In the USA and even in Australia, there were many people from conservative and Christian backgrounds who saw HIV either as a gay cancer which would wipe out homosexuality, or alternatively as a plague which homosexual people had brought upon the broader society. The legal and cultural marginalisation of gay people was one of the factors that led to its spread. And we know how to avoid HIV. We know that there are certain high-risk groups such as intravenous drug users and men who have sex with men. But it was difficult to encourage safer sex behaviour among those men when they were already marginalised and often closeted, by which I mean pretending to be heterosexual. Gay people suffered such discrimination that they were often also affected in their mental health, which in turn increased the likelihood of them engaging in risky behaviour such as unprotected sex and drug use. It's a vicious circle. Surely when we have a group in society who are particularly vulnerable and particularly affected by an incurable disease, surely that's a group the law should protect. What do we have a society for? What do we have a law for, if not to protect the vulnerable? I mean, it's one thing to decriminalise homosexual sex, but surely the law's capable of better than that. Well, in 1984, the Sex Discrimination Act seemed to be moving in the right direction. There were efforts to argue in the courts that discrimination on the basis of sexuality was a form of discrimination on the basis of sex. The courts disagreed. There were a few piecemeal bits of legislation here and there to protect gay people, but as late as 2011, the Australian Human Rights Commission found that there were very few protections for homosexual people in Australian law. In 2002, the law in Queensland was changed to protect gay people from discrimination. But if you can believe this, it wasn't until 2013 that the Commonwealth law in Australia was changed to make it unlawful in Australia to discriminate on the basis of sexual orientation. 2013. And then in Queensland, it took until 2016 for the age of consent for homosexual sex to be reduced from 18 to the standard age of 16. My point is that none of this is historical. There are thousands of LGBTI Australians who have had that same experience that Michael Kirby discussed at the outset of this video, of hiding, of feeling that society required them to be ashamed, outcast, unworthy of the protection of the law. Even once those big keynote pieces of legislation began to be passed, there were still dozens and dozens of smaller discriminations lurking in the laws. Could gay couples adopt? Could lesbian women access IVF? How did superannuation work in the case of an LGBTI couple? In this course, we've already learned about the gay panic defence. Well, was that to be allowed? How many other pieces of legislation were heteronormative, in other words, assuming that everyone was straight? How did that disadvantage people? Even as first-year students, you'll have noticed that sometimes with the law, the devil is in the detail. Well, enter into the scene the most unlikely gay rights champion you've ever heard of. A crocodile hunter and self-described progressive redneck from Cairns. A straight man from the Conservative Liberal Party who had a moment of blinding realisation and who realised that his gay mates needed help. His name was Warren Entsch. And for years he worked in the Parliament, finding one after another of these tiny little discriminations and eliminating them. Now, he became a well-known figure during the marriage equality debate. We'll talk about that shortly. But before that, for many years, he was just a simple backbencher, plugging away without a great deal of recognition to reduce discrimination because it was the right thing to do. Bloody good on him. Now, so far, I've mainly been talking about homosexuality, so the LGB bit of LGBTI. In some ways, the other two groups, Transgender and Intersex Australians, fit a little bit oddly within the acronym, because being a transgender person or an intersex person doesn't really say anything about a person's sexuality. And yet, on the other hand, the acronym works, because the experiences of many transgender people and intersex people has closely echoed that of lesbian, gay and bisexual people. So what do we mean when we say that somebody is a transgender person? Sociology tells us that there's a difference between a person's sex and their gender. Sex describes biology, that is, whether a person has male or female sex organs. Gender, on the other hand, is a matter of self-identity and whether a person feels comfortable following the social expectations of a person of their own sex, or whether they have some other sense of self-identity. In the overwhelming majority of cases, people's sex and their gender are the same. People with male sex organs follow the social expectations of men. People with female sexual organs follow the social expectations of women. A relatively small number of people have a condition known as gender dysphoria, where they have the sex organs of a man and yet within themselves feel that in their core identity they're a woman. Or they have the sex organs of a woman and yet feel that in their core identity they're a man. Responses to gender dysphoria vary. At the most mild end, you might have, say, a person with female sex organs who generally presents as being female, but who exhibits a number of behaviours more common among men. At the other extreme, you might have a person who undergoes hormone treatment and gender reassignment surgery, which is more properly described as sex affirmation surgery, to fully and completely change their sex. In recent times, we've also seen a related social phenomenon called gender fluidity, where people whose sex organs are obviously fixed deliberately choose which of the social constructs applicable to their sex they wish to exhibit. Transgender people have faced some serious legal issues. Socially, they've been exposed to ridicule and contempt. Even in the high point of recognition of transgender people within popular culture, they were seen as a spectacle in the movie Priscilla, Queen of the Desert. In reality, though, many of the legal problems faced by transgender people were much more prosaic. Can they get their birth certificate changed? As a person with male sex organs who presents as female, which bathrooms are they entitled to use? Should their gender reassignment surgery be publicly funded? Until 2017, in most states in Australia, if a person whose gender was recorded at birth as male married a woman, but then they transitioned to become a woman, they were forced to divorce because our laws didn't recognise same-sex marriage. In other cases, transgender people who were married were prevented from changing their gender on their birth certificate to keep their marriages compliant with the law. Transgender issues have come before the High Court on a number of occasions. One of the most prominent is known as Re Kevin, or Kevin's case. This involved a person who had transitioned from female to male sex and who had then married a woman. The question before the court was whether their marriage was valid because, of course, at the time, marriage was only possible between a man and a woman. The court found that the marriage was valid, even though it was a marriage between two people who had both been born with female sex organs. This was an important case for the recognition of transgender people in Australia. Another prominent case was Norrie's case. Norrie May Welby was born with male sexual organs but found that she did not identify as male. As a result, she underwent surgery in 1989 to provide her with female sexual organs. She found over time that she did not identify as female either. She underwent further surgery and applied to the New South Wales Register of Births, Deaths and Marriages to have her gender recognised as non-specific. The registrar initially agreed but then refused, and ultimately the High Court supported Norrie's right to be publicly identified as neither male nor female. Finally, there are a group of Australians who we describe as intersex. Intersex people are usually born either with no sex organs or with sex organs that are not determinate. They may also have genetic characteristics which don't conform with either standard male or female genetic characteristics. In the past, intersex people were generally treated as having medical or surgical anomalies or deformities, which were treated as though to correct a problem. More recently, some intersex people have chosen to identify simply as intersex, to regard their body shape and genetic characteristics as being the perfect expression of themselves, not requiring any medical intervention. And many intersex people choose to live their lives in an authentic way without pretending to be male or female. This sometimes throws up legal difficulties where the law expects that people can be classified in simple binary gender terms as male or female. Finally, let's end this video on a happy note. For all but the last few minutes of Australian history, marriage has been confined to relationships between men and women. This was initially the result of the common law and was written into statute in 2003 during the Howard government. As homosexuality became less and less stigmatised within Australia, pressure began to arise for gay people to be allowed to marry, that is, to have their relationships recognised in the same way that a heterosexual relationship might be recognised. Pressure was sustained on this point for years, but the political will on both sides of federal politics was lacking. A number of states tried a halfway house of civil partnerships, which looked very much like marriage, but which were still distinct from marriage. The objection was pretty simple, really. No matter how much you slice and dice it, the previous situation discriminated against gay people. The institution of marriage was closed off to them simply because they were homosexual. Eventually, in 2017, at the insistence of a Liberal senator named Dean Smith, the government started to genuinely confront the issue of gay marriage. But governments being governments, they did so in the most ridiculous possible way. You see, the Parliament had the power to allow marriage equality. It could have done it in an afternoon if they'd wanted. But they lacked the courage, and they squibbed it. and instead spent millions upon millions of dollars to hold a non-binding voluntary plebiscite where Australians voted on the question of whether gay people should be allowed to marry. This plebiscite was preceded by a 2-month period of public debate, a 2-month period of the most ridiculous torture of gay Australians who had to endure public discussion about whether they and their love and their relationships were valid. It was awful and awfully unnecessary. Thank goodness the Australian public came to the rescue. A massive 61% of Australians voted yes. Only New South Wales had a support rate less than 60%. Faced with such numbers, the government had to act, and laws enabling same-sex marriage were passed by the end of 2017. The Prime Minister claimed it as a great victory for love, but the truth is he and his party were dragged kicking and screaming to a decision they could have made on their own. To me, the day really belonged to Dean Smith and to Penny Wong, a gay Labor senator whose reaction to the announcement will surely be remembered as one of the classic moments of Australian politics.
Reflect the view of the eligible population. And now the official results of the Australian Marriage Law Postal Survey. For the national result, yes responses, 7,817,000. Yeah! Representing 38.4% of the responses. 38.4% of the responses. So the 36,686 responses were unclear, representing 0.6% of total responses. At a certain level, every state and territory recorded yes.
Grouper. Bloody a grouper. Right.
Shouldn't have had to.
So you're worried over that one.
Was that kiss what won it?
Right.
61.
Remember the words of Justice Michael Kirby. The law can be an instrument of liberty or of oppression. The law can be an instrument of equality or of discrimination. The law can be an instrument of human happiness or of cruelty and unkindness. As legal professionals, we have a special duty to promote liberty, to promote equality, to promote human happiness. Lofty goals, but why shoot low?